Excellent. So thanks for joining us.
No, thank you.
So you've been quite involved engaging with the engineering field. You had a presentation with Engineers Australia, for example, and you've collaborated on this paper. So why you as an industry lawyer, why are you choosing to engage in this discussion, co-write a paper with us and really try and speak to engineers?
Probably a couple of reasons. I've been writing about the problems with safety management from a legal risk management perspective for a long time now. The fact that our documented systems are too bureaucratic, they're not workable, the fact that our safety metrics are unhelpful to understand safety risks. So I've always had an interest in trying to understand how can we better align what we do in safety management in the broad sense to help to manage legal risk. So that's always been an interest. But a few years ago, and this really sort of sparked me into this area, there was a series of papers and articles and books that sort of came out and said the WHS legislation has come into effect. It introduces this so-called new test of so far as is reasonably practicable. It is fundamentally different from the old test of as low as reasonably practicable, and we need to approach all of this completely differently, which I thought was just, it was wrong. That's wrong. It's factually wrong. It's not what has occurred. I found it very misleading, and I found it creating a lot of confusion. And the more I got involved in those conversations, I came to realise how much confusion there actually was within an engineering community about this test of reasonably practicable and what it means.
Yeah.
So that's where the interest has come from.
And that part of you doing that review and research, did you find the driver for that confusion from the engineering field by that?
No, I didn't find the driver as such, but there was certainly, I think, a misconception that around a couple of things, ideas around things like a LARP being some sort of legal test, which it's not, tolerability, again, being some sort of legal test, which certainly in an Australian context, it isn't. And the idea of acceptability of risk somehow, again, being a legal test or a legal boundary, which again, certainly in the context of Australian legislation, it's not.
All right, thanks. So in simple terms, what does reasonably practical mean under Australian work health and safety law, and why is it such a central idea that's applicable to dam owners?
Well, reasonably practical, and I need to make the point because this is where we get confused. The legally defined term in work health and safety legislation in Australia, and that would include the Victorian Occupational Safety and Health legislation, and noting that we're in New Zealand as well, the New Zealand work health and safety legislation. The defined term is reasonably practicable, and people often think the defined term is as low as reasonably practicable or so far as is reasonably practicable. And as low as or so far as are simply the precursors to the word. The definition is reasonably practicable. And there's two parts to it. So in layman's, or paraphrasing if you like, the definition of reasonably practicable goes to what an organisation knows or ought to know about a risk, about a hazard, so what can cause harm, the risks represented by that hazard, how likely is it, what are the consequences going to be, and what the organisation knows or ought to know about the controls to mitigate, eliminate or mitigate those hazards. And then there's a balancing exercise where we have to understand what's the availability and suitability of those controls, and underpinning it all, there is a cost test which talks about the cost. You don't have to implement something if the cost is grossly disproportionate to the risk. Now, you won't find cases that talk about cost. It just doesn't come up in the cases. So that's kind of a paraphrasing of the definition in the legislation. In practical terms, when we're having arguments in court, when we're in prosecutions particularly, and we're having arguments about what's reasonably practicable, what we are talking about is whether the organisation has got proper systems to manage the hazards in the business. And proper systems is really about, do your processes align with the regulations? Do they align with codes of practice? Do they align with standards? Those sorts of things. And that's kind of the easy part of the equation. Most large, sophisticated organisations can more or less point to that proper system. The challenge is what the courts describe as adequate supervision. And in the cases that talk about adequate supervision, they're not just talking about what supervisors do, they're talking about whole of organisational assurance. So how do we know that our proper systems are implemented and effective? So if we take a really simple approach and we say, we are going to use we're going to do risk assessments, and our tool for doing risk assessments is we're going to use a 5x5 risk matrix. So as an organisation, if you rely on that kind of risk assessment approach, what evidence do you actually have in the organisation that that approach is being done properly, it's being complied with properly each time, and it's actually effective to identify and manage the risks? And the sorts of things we see that undermine those kinds of processes, and it's not just that process, I'm not picking on that, it's all sorts of processes. The sort of blatant copy and paste of risk assessments that occurs. Sure. So straight away, if we're copying and pasting from one risk assessment into another, that immediately calls into question the efficacy of what we've produced.
Yeah, okay. Just come back to you mentioned cost and that review of cost, and you said it hasn't really come up. Is that because the cases are decided much earlier than that, or is it found that the discussion of cost or the deliberation of cost when something has occurred is not defensible?
So a couple of reasons. One, there's a very pragmatic reason. 97%, looking at the last numbers from Safe Work Australia, 97% of occupational or work health and safety prosecutions end up in a guilty plea. So we're not having arguments about anything. I've just pleaded guilty and I'm trying to reduce my penalty.
Okay.
But the more pertinent, I guess, answer to that question is that most prosecutions for health and safety involve a departure from an organisation's policies or procedures.
Okay.
So we say, here's our policy and procedure for doing this work. That procedure hasn't been followed and incidents occurred. And so you can't argue that cost is grossly disproportionate if you've already said we're going to do it.
Okay.
So procedure says we're going to do X, we didn't do X. Well, you can't then turn around and say, well, we didn't do it because it was too expensive.
Right, okay.
Yeah, so it's very practical in that sense.
Yeah, okay. And that discussion about gross disproportionality, would it ever be defensible to try and quantify, say, life savings versus the cost of a control that would eliminate or mitigate the risk?
Yeah, I think it would. I think, again, it's really hard to say because it's never really been tested in terms of what grossly disproportionate looks like. And often because the remedies that would have prevented an incident are normally not very expensive very often. Yeah. But that would certainly be a criteria, I think, that would be a valid criteria to say, well, the likelihood of somebody dying was X.
Yeah.
And that's, was so remote that the cost didn't justify it. Yeah. Again, I think it's worth considering in that kind of conversation that when you talk about prosecutions, we're never having finely balanced arguments.
Yeah.
So it's never sort of, if you've got grossly negligent up one end and completely safe at the other, and somewhere in the middle there's this fine tipping point, prosecutions are never at the tipping point.
Okay.
They always happen when it's a clear, almost always happen, I'll say, where it's pretty clear that there are things that could have been done to manage the risk better.
Right, okay.
Yeah.
So many engineers use the notion or concept of ALARP and risk tolerability thresholds as a benchmark for safety decisions. So can you explain if ALARP and risk tolerability, especially as outlined in the ANCLED risk assessment guidelines, are legal concepts in Australia, or better down from legal concepts, and how these terms are related to the obligations under work health and safety legislation?
Okay. So when you look at tolerability and ALARP, they're largely drawn from guidance material from the UK HSE. So I think that's generally understood.
Yeah.
They are not legal concepts in the sense of a prosecution. So a prosecutor will never allege that a risk wasn't tolerable, or they will never allege the risk wasn't ALARP. the argument, or the way the prosecution frames their charges, is to say that the organisation failed to do everything reasonably practical because it did or didn't do X, Y, and Z, and then they'll set out the particulars of the charge. So we're never having arguments about ALARP, we're having arguments about reasonably practicable, and we're never having arguments about tolerability. And those terms simply don't come up in prosecutions under safety legislation in Australia. And the only time I've seen tolerability come up is where the court has said the question of whether or not an organisation decides something is tolerable is not an answer to the question of whether they've done everything reasonably practical.
Completely separate.
Yeah.
Yeah.
So if you go back a step, there's a case called Slivak and Lurgy, which is I think a 2006, I want to say, it could be wrong, High Court decision. And Justice Mary Gaudron in that decision talks about reasonably practicable being a judgment call or a balancing exercise, where you have to balance the time, cost and trouble of managing a risk against the risk of that thing materialising. And I think in that sense, what tolerability is just a tool to help make the judgment call.
Right.
It's a common language that people can get around and say, we're going to make this judgment call, is it tolerable? But I think you have to recognise that just because something's tolerable doesn't mean you've done everything reasonably practicable. And it's also, I think, important to understand that, and we run into this same dilemma when we talk about low risk and high risk. So we say, oh, if something's low risk, it means we've done everything reasonably practical. That's not true. Mm-hmm. It can still be low risk and you haven't done everything reasonably practicable to manage it, because there might be things that you could do relative to the level of risk that should be done and reduce it even further. And the one that annoys me even more is this idea that because something's high risk, we haven't done everything reasonably practicable. And again, that's simply not true. And I think that leads to very misleading risk assessments. Mm-hmm. So the reality is most of our risk assessments should identify a lot of what we do as being high risk, because it is high risk, because if the controls fail, somebody's going to die. That doesn't mean that I haven't done everything reasonably practicable to manage that risk. So for most people, the biggest risk I face in a day is to jump in their car and go driving. And there's a whole lot of things I can do to manage the risk of driving. I've got a licence, I've got an ANCAP, 5-star ANCAP rated car, I wear my seatbelt, I'm not drunk, I'm not distracted, all of that. It's still a high risk activity, because if something goes wrong, I could die. Mm-hmm. So I think we tend to mislead in our risk assessments because we want to show everything as being low risk when that's just not right.
Yeah, we should really try and separate the concept of, say, some perception of level of risk and what we've actually done to manage the risk is really the message.
I think, yes, I think so. I think that's right. I think you can have done everything that you would be expected to do to manage a risk, and it would still be a high risk.
So in the risk assessment guidelines, the results are a quantified risk profile within a tolerability framework.
Yep.
And often practitioners or decision makers would point to that and say, my risks are, or the risk is tolerable, or the risk of the dam is ALARP.
Yep.
Does that make sense within the legislative framework?
Not when you're talking about reasonably practicable.
Yeah.
So what you've done there is you've quantified the risk, mm-hmm. and you've put it into a risk matrix or a risk hierarchy somewhere, and low, medium, high, or however you quantify it. But the reasonably practicable assessment is not about the level of risk, it's about what you have done to manage it and what else could have been done to manage it.
So what physical controls or processes or systems you put in place, rather than a quantified expression of the risk of the asset.
Yeah, so the courts would never look at your risk assessment and go, oh, you've identified this risk as a 1 in 10,000 year event, mm-hmm. for example, and say, therefore, because you've quantified it that way, therefore you've done everything reasonably practicable to manage a risk.
Yeah.
That's not the discussion. The discussion is what could you have done, mm-hmm. to mitigate that risk, and it never exists in a band.
Yeah.
So a lot of the material that we see that has risk assessment sort of puts things into a band. When we're in court, we're not arguing about a band, we're arguing about a line.
Yeah.
So it's either reasonably practicable or it's not.
Right, okay.
So a very simple case, and on risk assessment, I was looking at a decision the other day. It's a bit of an older decision, and the prosecution had alleged that a worker should have done, or there should have been a documented risk assessment for a particular task. And the court said, well, no, that's not reasonably practicable, because if you had done a documented risk assessment, you would not have come up with anything different than what was identified anyway. The workers understood and identified the risk. They knew what the risk was. Formally documenting it doesn't make any difference.
Okay. So a formal risk assessment is not a prerequisite either to then demonstrating that you've done everything reasonably practicable.
No, it's an interesting dilemma. The regulations, the WHS regulations describe a formal risk assessment process. They say this is what you have to consider, and when you have to consider it, and how you have to consider it. But it doesn't say, and you have to document it. And it doesn't say, and when you document it, it has to look like this, and it has to go from high to low. That's all things that we've put in place to try and corral, I guess, that obligation.
Yeah, okay. Going back to one of the points you mentioned about HSE from the UK,
Yeah.
and a lot of the technical guidance, especially around ALAP and tolerability being based upon their work. Can you just provide some context about HSE and how relevant or non-relevant it is for Australians?
HSE UK material, it's never quoted in, or never might be putting it too high, but if I look at the cases since WHS legislation's been in place, and you look at all the prosecutions that have been run, they don't refer back to, no one's arguing about the principles or the guidance coming out of the HSE UK.
Not relevant.
It's not anything you would argue about. I would never, I had sentencing submissions the other day, and I wouldn't even think to turn my mind to what the HSE UK might say about risk assessment.
Yeah, and
we've got our own codes of practice and guidance material. That's what we ought to be relying on.
Yeah, and to confirm, their role as a regulator in the UK?
Yes.
Yeah. So given that ALAP and risk tolerability are not legal concepts, why should it matter to dam owners that they are basing their decisions on these terms and concepts, especially if the decisions they've made have resulted in there's been no dam failures while they've been basing their decisions on those concepts?
To take a step back, I'm not suggesting for a moment that the primary reason that we do safety management is for legal risk management.
Okay.
Right, we do safety management to keep people safe, people and communities safe. Right? But one of the very real consequences of a failure to get safety management right is legal consequences, and the legal consequences have been moving very rapidly up. So why should I, as a duty holder, let's put it even more broadly, should I as a duty holder under health and safety legislation be concerned about whether our processes to manage risk are aligned with the legislation? Because it creates legal exposure. That would be the simplest answer to it.
Yeah.
And I think if history teaches us nothing else, we need to be extraordinarily careful about taking comfort from the fact that nothing has gone wrong. Many of the worst industrial accidents on the planet in the last 30 years have been preceded by long periods of nothing going wrong. And what is interesting is that when something eventually does go wrong and the inquiries go back and look at the systems in place leading up to that, almost universally those systems are found to be fundamentally flawed. So I think that's where the concern ought to be.
Yeah, and in your presentation that you did with Engineers Australia, I recall as well you said whatever processes a PCB puts in place to manage their risks is their own business, but they should consider, I think you're imploring people to at least consider their legal obligations as well.
Yeah, look, if and again, you take, and this is part of the wriggle room that happens around here. If we're in a courtroom arguing about what's reasonably practicable, that's in the legislation. That's how we deal with it, right? If you set up your own policies and procedures and you define reasonably practicable different, or you substitute it with a LARP, or you use tolerability, again, that's your business. You use whatever language you like to describe whatever you do. If something goes wrong, you won't be held accountable against the standard that you've described in your system. So you're held accountable against what the legislation says.
Yeah.
And this is kind of a frustration. So everybody talks about legal compliance as a minimum requirement, okay? Which I think really misunderstands legal compliance, but leave that to one side. I would have thought that if legal compliance really was the minimum expectation, then you would just take those definitions and say, this is the foundation we're going to use to build our framework to manage risk.
Yeah.
And then because anything over and above the legal minimum has got to be better. But we don't do that. What we do is we create phrases like tolerability, which often get applied in practice in ways that are not consistent.
Yeah, and another example would be ALARP from some concept or some acronym of reasonably practical.
Yeah. And to be fair, the ALARP concept has been drawn from the early sort of 1930s, 1940s UK decisions, and that's where our legislation has evolved from. So there is a pedigree that comes through that history, but the notion of ALARP that is brought out of that case law has its own nuances and meaning that's been ascribed to it over the years. Whereas in the health and safety legislation, we have a very prescriptive definition of what we have to consider for reasonably practicable. And that may or may not be picked up in ALARP, depending on who's talking about it.
Yeah, and when you say ALARP having a pedigree from case law, that term ALARP though is used as an acronym and not anything else. Yeah, it is actually as low as reasonably practicable, and you're using it as an acronym. Yeah,
well, it seems to. I get my nouns and verbs mixed up, so I apologise. But people look at it and say that risk is ALARP.
Yes.
And that's not the model of the WHS legislation. You have to manage your risks as low as reasonably practicable, which is not the same thing as saying there is a point where they are as low as reasonably practicable.
Yeah.
Fundamentally, if for no other reason, that the second that you plot that risk on some sort of matrix or wherever you plot it, 5 minutes later that risk profile has moved because people have done something different. So it's the problem with in part with the engineering concept around tolerability and ALARP is they tend to be fixed and static, whereas the risk management obligations are ongoing and live and proactive.
Moving on to one of the points you previously raised is that courts don't think in terms of risk probabilities, but in terms of foreseeability. I think that's one of the points you brought up earlier. So how do courts actually approach this idea when assessing whether someone has met their duty regarding foreseeability?
All right, so just two things. So there's two different types of things to consider. One is an inquiry, like coroner's inquest or royal commission, and one is a prosecution. Now, in a prosecution, the courts aren't making inquiries. So the prosecutor, I think I touched on this before, the prosecutor comes to the court with a charge and particulars, and they say, this company didn't do everything reasonably practicable, and here's what it was possible for them to do that they didn't do. And we're having an argument about whether that is practicable or not. Right? So, and foreseeability feeds into that question of whether it was reasonably practicable to do something. So to give an example, we had a prosecution the other day where I did the sentencing submissions. There was a piece of equipment that came loose during transport. The evidence was that my client, on one or two occasions, so this piece of equipment had restraining devices on it, and my client was aware that on one or two occasions their clients had removed this equipment without all the restraining equipment in place. And that was enough for the court to accept that it was foreseeable that clients might return the equipment without those things in place, and that made it reasonably practicable to put additional engineering controls to stop the equipment coming loose.
Yeah.
So that's that foreseeability question in the context of prosecutions.
Yeah. Okay.
And there's lots of things that feed into foreseeability. So there's kind of this what do you know or ought you have known. So for example, if there's a code of practice that applies to a risk, it's generally taken that you should have known about that risk, so that risk is foreseeable.
Okay.
Deal with it in that context.
Yeah. So then, comparing that then with quantified probabilities, a risk assessment perhaps should focus on identifying foreseeable hazards rather than trying to quantify the probability of that hazard.
It's an interesting question. I don't know what the practical difference would be between a quantifiable hazard and foreseeability. The fact that you can quantify it means it's foreseeable.
Right.
So if you can quantify it, that means you know about it, and you have some sense of how it might play out.
Yeah.
Which means that you then need, I know about this, I then need to turn my mind to what do I need to do to eliminate or mitigate that concern.
Yeah. So the example would be completing a risk assessment for a dam. We know that one of the hazards is large inflows from rainfall that will result in a flood. Often risk assessments, or risk analysis and risk assessments focus on quantifying the probability of a flood event that would result in, say, overtopping.
Yes.
It plots below a certain point, or it doesn't come up as, say, the most probable hazard.
Yep.
And that's the end of it, that hazard or that treatment of the hazard, rather than perhaps it sounds like you're suggesting that the focus rather should be on, have we done everything to manage the risk posed by these inflows?
Yep. So if you run sort of through the reasonably practicable occasion, we know that there's a hazard posed by rainfall events.
Yeah.
Okay. And so you say, well, you build a dam to a certain level, and you say we know that this dam is good for a rainfall event of X intensity.
Sure.
Okay. Sure. Then the next question becomes, okay, what would we have to do to mitigate a rainfall event of Y intensity? So the Y intensity is less common, and that's what in a WHS prosecution, the prosecutor would allege that it was reasonably practicable to take further measures to prevent against a greater rainfall event, and the measures that you should have undertaken were, I don't know what the technical things would be, but A, B, C, D, and E.
Sure.
And then we're just having an argument about whether, given the risk and the likelihood of that occurring, it would have been reasonable for you to have done those additional measures.
Yeah.
And that will be, there'll be interesting questions about, whether the technology existed at the time, or whether technology's changed. If technology's changed, could that technology have been incorporated into the dam? That's probably a case, if it went to trial, where you would have an argument about cost.
Yeah.
So this is a 1 in 500 year event. The cost is X, Y, and Z. But that evidence would be tested. So you would have your engineers saying, well, this is a 1 in 500 year event, and then the prosecution would call expert witnesses to say, well, we've done our modelling and we think it's a 1 in 250 year event. Or someone would say, because of climate change, and again, it's a timing issue, climate change impacts over the last 10 years have meant that risk has shifted. You might find that one of the allegations against a company in those circumstances, particularly in an inquiry, maybe not a prosecution, but in an inquiry, would be to say, well, that dam was built in 1991.
Yeah.
Climate modelling has changed since then. How often or when did you go back and revisit that dam design to take account of climate modelling, population change? Because the risk, there's a population downstream when you built the dam.
Yeah.
That's changed over 15 years. Do we go back and revisit the dam design Those are all the sorts of factors.
Yeah.
And sorry, just to go on that, I think this is the bit that we often miss in the application of engineering risk assessments, is they're fixed at a point in time, whereas the reasonably practical requires that ongoing proactive coming back to it.
Yeah, okay. Probably one point that I could make clear as well, often the controls are physically constrained and apparent. So another example we've come across as reviewers, there's a dam, there's a failure mechanism called internal erosion where effectively seepage washes out material and it keeps progressing, and all of a sudden you don't have a dam wall, you have a pipe connecting downstream to upstream. Yeah. We've seen risk assessments done saying the risk or the likelihood of piping was 1 in 100 based on a very simplified approach, which for dams is ridiculously high. We would consider that, like, if you're talking about 1 in 100, that's very high. However, within the owner's 5x5 matrix, that was considered a rare risk or some very, very low likelihood, because it's 1 in 100 for health and safety incidents, high consequence. We were reviewing it and said, okay, you've got this risk assessment for this piping failure. The ways to address it, though, are well known, not novel, and can be carried out.
Yep.
So we argued the risk assessment should have been focused on identifying that it could occur and then addressing it, rather than spending time and cost deliberating about what the probability was, and then whether or not something should be done about it.
I think that makes sense. And again, from a legal risk management perspective, it would be a case of the things you've pointed out. It's a known risk with known controls. So the only question we're really arguing about is whether the time, trouble and effort to address that risk is outweighed by the potential likelihood and consequence of that risk.
Yeah.
And that would be all we're arguing about.
Yeah.
And the fact that an organisation may have quantified the risk as 1 in 100, which I agree probably sounds high to me. Everybody talks about driving as being this critical risk in their business. I think the likelihood of being caught in a car accident is probably higher or less than 1 in 100. But anyway, that's by the by. Where you've plotted it on your risk matrix will not, necessarily be determinative of any of those questions.
Yeah. You mentioned that balancing just then about cost, time, effort versus the benefit. And I think we talked about grossly disproportionate before. As engineers, we're almost compelled to try and quantify all aspects, or try to quantify all aspects of those things, and then balance that.
Sure.
Is that sound decision making?
Yeah, I think it is.
Okay.
But it's not determinative.
Yeah.
It gives you it's a stepping off point, not a finishing point, in my view.
It's an input into a decision.
I think so. Yeah, I think that's
it's not the decision.
That's right.
Yeah.
And you have to remember, and this is terribly unfair, but you have to remember that we are arguing about this after the event.
Yeah.
And after the event, everybody will be able to point to all of the things that made it perfectly clear why this was going to happen.
Yeah.
So, I think you do need to err on the side of conservatism in risk. Simply, that's not a legal issue, it's just a fact of life.
Yeah. Okay. So you've been involved in inquiries and prosecutions. From your experience, what do courts or investigators actually examine when something goes wrong? And how could this inform dam owners? And again, going back to that ALARP and tolerability, would an argument like my risk profile was tolerable or was ALARP carry any legal weight?
Your risk profile and your conversations about tolerability and ALARP will form part of the evidentiary mix in that balancing exercise between time, effort, and resources versus what's the risk we're dealing with. Now, the exposure or part of the exposure in that conversation is that your risk decision-making processes will be heavily scrutinised.
Okay.
So the decision making that led you to that point will be heavily scrutinised. I think the best example of that, if people are interested, is there's the presidential inquiry into the Deepwater Horizon disaster. That's page 125 of the presidential inquiry. And on there is a table of decisions, and it talks about what the decision was, whether there was a less risky option available, whether the riskier decision saved time or money, and who was the decision maker.
Yeah.
And that's, I think if you look at a table like that, you get a sense of how your risk decisions get scrutinised when things go badly wrong.
Okay.
What was the decision? What were the inputs? What was considered? What wasn't considered? Even things, so there's the prosecution of a fellow called Mr. Gibson in New Zealand, who was the Chief Executive Officer of the Port of Auckland. He was prosecuted for breaches of due diligence. Now that case is going to the High Court, so we'll have to see what falls out. But one of the things that was looked at in that case, just to give you a sense of how this happens, was there was I think it was the Health Safety Something Committee, was the most senior sort of oversight safety committee of the port. And there's conversations in that decision about who attended, how long they attended for, how long the meetings ran for, to form a view that that committee couldn't do what it was supposed to do given the attendance and the timeframes.
Yeah.
If we're in a major inquiry, that same sort of exercise will be done over your risk assessment processes.
Yeah.
When were the meetings held? Who attended them? How long did they run for? Who had input? What was the expert advice? They'll come under a pretty close level of scrutiny.
Yeah, okay. And go back to that decision making then, if you're and what you mentioned earlier about risk assessments being perhaps a starting point or an input, if your sole decision is my risk profile is below a certain point or plots in a certain area, I don't have to do anything.
Yep.
That's where you come unstuck.
But potentially, look, it's hard to say, because from a very practical, what you're doing there is taking a very pragmatic approach. And what you're saying is, we think this is so low that nothing's going to happen, so we don't have to worry about it.
Yeah.
That's not the application of reasonably practicable in a technical sense, but it is in a kind of a practical sense to say that's low enough not to worry about it. Now, again, from a technical legal perspective, could we look at that and say there were things you could have done that would have mitigated that risk further? Yes.
Mm-hmm.
And I think I think that would be problematic from a legal risk management perspective. But again, I understand why you would do that.
Yeah.
And I guess from a very practical perspective, if you're going to take that sort of risk, do it at the low end of the risk profile.
When you say you take the risk, as in the organisation taking on the risk of not doing anything based on a risk profile.
Yeah. If that's if you're comfortable not to do that, I would probably accept that.
Yeah.
So long as you're putting the right level of attention into the risks that are problematic.
Yeah.
But I think the real, like for an organisation, I think one of the real risk questions is how much time and effort do you want to put into verifying and double checking that risk assessment?
Yeah.
Because as you say, if there's a line below which we don't have to do anything more, the risk is that those risks tend to get pushed towards that line, so we don't have to do anything more.
Yeah.
And that's one of the dangers in that kind of a model.
Yeah. You mentioned as well, we're looking at this from, especially when you come into it, after the event has happened.
Yeah.
If a risk is low, especially for the types of assets we're talking about, it means the probabilities are quite low.
Yeah.
But as you say, the event has actually happened.
Yeah. So yeah, that's probability is one part of the equation, consequence is the other.
Sure.
So so balancing that's important.
Yeah. So if you were advising a dam owner today, what would you say they should focus on to ensure their decisions on dam safety are legally defensible?
The one thing I always tell organisations, do you have proper systems to manage the risks, and are they implemented and effective? Mm-hmm. And that's when ultimately if something goes wrong, that's the conversation we're having. What did you have in place to do the risk assessments, to make the decisions about what's an acceptable level of risk, about how the risks are going to be controlled, were those systems being complied with. Again, if you look at the page 125 from the presidential report, one of the criticisms was these riskier decisions were being made without any formal risk assessment process being applied.
Okay.
So how confident are we that our risk assessment processes are being properly applied? How much assurance do we have that they're effective, that the controls are effective?
Yep.
Continually revisiting that loop.
Yeah. And would you have any advice regarding the types of outcomes of a risk assessment? I think you mentioned everything being done to manage the risk,
Yeah.
versus, say, quantifying risk. Is there some type of preferable outcome of risk assessments you would advise?
No, I don't think so. It's from a legal risk management point of view, the starting point is, have you complied with your own process?
Okay.
And then that process produces an outcome.
Yeah.
So again, and I'm not saying this is inappropriate in any way, shape or form, but it produces a quantifiable list of risks and where they sit, some of which might require more action, some of which don't. You will inevitably be applying the organisation's own risk appetite to that.
Yeah.
So even if you said, let's take the technical definition of reasonably practicable and replace tolerability, you would still bring the organisation's risk appetite would still interpret reasonably practicable.
Yeah.
But so that you've followed your process, you've produced an outcome. The question then becomes, this is kind of the risk question, or a secondary level of risk question is, how much of that outcome do we want to subject to scrutiny? Right. Do we want a further review done of that risk outcome? And if we get a further review done, do we want a further review? So, checkers checking the checkers.
Yeah.
I think that's the real question about where do you draw the line that you get assurance that what you've done is an effective outcome.
Right. So really it's about, do you have the right systems and processes in place? Are they being implemented? And then, say, for a particular type of hazard, does it align with the organization-wide policy, systems, processes as well?
Yes, I think that's right.
Yeah, okay. So the paper we wrote together calls for ANCL to realign its guidance with Australian legal principles. From your perspective, what would that alignment look like?
I think for me, the key issue is to recognise that it is technical guidance, not legal advice. And it's technical guidance. So if you think of it, so reasonably practicable is this life cycle, ongoing, proactive issue. I'm not an engineer, but the guidance that we're talking about is technical design guidance. So I think there needs to be much more overt recognition that it is design guidance and design
risk assessment, technical risk assessment guidance.
Yes. Yeah. For design.
Yeah.
Correct? Yeah.
For existing, or for design and existing dams.
Yes, yeah. So I'm being a bit shorthand there, but some overt recognition of what it is, and that it is that. It is not guidance on the overall reasonably practicable life cycle, for want of a better word. Mm-hmm. It's kind of a point in time assessment. And it's not legal advice.
Yeah. So don't make bones, or don't make any presumption or appearances that it's legal guidance.
No. Yeah. I don't think you can say, if you follow, so what you might be able to say is, if you follow this guidance and you do it properly, this will deliver the best kind of risk assessment of a dam you can have.
Sure.
Okay. But to then say, because we've done the best risk assessment of a dam, we've done everything reasonably practicable.
Yeah.
They're not the same things.
Yeah.
And I think that distinction needs to be fairly clearly drawn.
Yeah.
I think the best idea for writers of technical guidance material is to make no observations or commentary about the legal impacts of that at all.
Yeah. And you mentioned having, say, the best risk assessment not being the same as doing everything reasonably practicable. I think we talked about the practicalities of risk assessments. They're very time and cost intensive, and decisions are made on them regarding whether something should be done.
Yep.
I don't know if you have any personal views that that sort of assessment then, especially if we know that they are being made for risk management decisions, really should be secondary then to assessments on what controls should be put in place for these risks. So if you were to do both assessments or both types of assessments, they would stem from what can go wrong.
Yep.
The type of risk assessments in the guideline would then focus on quantifying the potential consequences and likelihood, with what we can do about those hazards being almost a tertiary consideration in that process,
Yep.
rather than being the primary focus of those risk assessments.
I think the risk assessments, and you used the term before, create the decision point.
Yeah.
So we've got something that can cause harm, we've assessed the potential impact of that harm, and we've looked at all the ways we can control it, and having done that exercise, we think this is a suitable way to manage it. Then that's the technical input. That requires a decision that says, yes, that's as far as we're going to go, or no, there's other things we think we can do.
Right.
That's the risk assessment feeds into the reasonably practicable equation, because it informs us, it tells us what we know or what we ought to know about the hazard, about the risk, and about the controls.
A more practical example of that is we've seen 5x5 matrices, and dam failure almost invariably plots in the most extreme end with very high consequences but very, very low likelihoods. And often those types of frameworks have that as just monitor because the likelihood is so low. So the process doesn't even allow or require people to consider what can be done to manage the risks, despite, as we said, despite the risks, or what can be done to manage risk being quite low, like the piping failure I was talking about.
So I think what's particularly, the fundamental problem I have with that, and this is, I'm not mathematics, I'm not talking from a mathematical perspective, but there's two parts to that equation, likelihood and consequence.
Yeah.
And if you only base your decision making on one of those criteria, then I think that's really problematic. If you're saying it's really, really low, and even if it does go wrong, the worst case scenario is no harm, that, yes, fine, forget and monitor that.
Yeah.
If you're saying, look, this is really, really low, but if it does go wrong, 1,000 people could be killed, then I think that warrants a conversation about, can we do more to manage it?
So that's at the asset or that risk assessment level. We've seen frameworks set up where if it plots in that region of very low likelihood but very high consequences, it doesn't drive the need.
I think that's a mistake.
Yeah.
I think it should at least be closed out with a conversation about, is there more we can do?
Yeah. And again, we've seen internal processes for risk assessments where the first step is to quantify both the potential consequences and likelihood of a hazard, rather than assessing what can be done to manage that hazard. Is that a mistake? And again, especially considering the amount of cost and time that goes into a quantified risk assessment, we just see a lot of effort being expended on that, and that being the focus, rather than saying, hey, we know that there's this risk of piping, for example, we know what we can do about it, let's not worry about quantifying anything.
I don't know if mistake is putting it too harshly,
Okay.
but again, sort of coming back to where the discussion has been, if something, so what you're doing is you are effectively staking your ground on, it is such a low likelihood it's not going to occur, therefore we don't need to think about it anymore. If it does occur, all of the conversation will be about what could have been done to mitigate that risk further. Or absolutely that conversation will happen. So I would have thought that any risk in an organisation warrants at least some level of consideration of is there something more we could do to mitigate this? And if you look at it in the context of principal hazard management plans in the mining industry,
Yep.
which overtly call out you have to identify what you're going to do to control it,
Yeah.
and you also have to overtly say what things you decided not to do. So yeah, I think there is a place for that. If an organisation wants to draw a line in the sand and say below this line we're not going to have that conversation,
Yeah.
that is the risk appetite of the organisation. You can call it tolerable, you can call it acceptable, you call it whatever you like.
Yeah.
But the fact that you've called it something, you've drawn the line and you've put something below the line is not determinative of anything that will happen in legal proceedings.
So that tolerability is not anything to do with the risk of the asset or the hazard, but really around the appetite of the owner of that risk. They're saying for them it's tolerable.
And I think most formal risk assessment processes
Yeah.
necessarily have an inbuilt bias in terms of the risk appetite of the owner.
Mm-hmm.
Ultimately, that's what it is.
Yeah.
And if you're not going through the exercise of saying, is there anything more that we could do to manage this risk?
Yeah.
You're really not stress testing your risk appetite.
Yeah.
You're setting the line, and that's what it is.
Yeah. I don't know if it surprises you. We see that though being done more and more often, and often those who are carrying out risk assessments, especially the owner's representative, not at least being aware or conscious that discussion about tolerability or acceptability is more the subject of the owner's risk appetite. Rather, I've heard risk assessment risk managers saying this risk is the risk of the dam is tolerable because it's here, rather than perhaps saying we consider this risk tolerable for our organisation.
Yeah, and it'll be for the same reasons, but
Yeah.
I mean, there's a common parlance in safety management. We talk about the efficiency thoroughness trade-off.
Right.
What you're describing there, it very much falls into that basket of the efficiency thoroughness trade-off.
Mm-hmm.
It is very efficient to set a threshold around likelihood, do your calculations, and if it drops under that threshold, not worry about it anymore.
Yeah.
That's a very efficient way to deal with risk when you're dealing with lots and lots of risks that you're trying to manage. And so that is, you'd like to say it's conscious decision making, but I think very often it's invisible decision making, because we've set the threshold and we think that threshold means something more than it does.
Yeah.
And it certainly doesn't mean that the fact that it drops below a threshold based on likelihood, no matter how large or small, I don't know the correct mathematical way of putting it,
Yeah.
the number is not the same thing as saying that you've done everything reasonably practicable to manage that risk.
Yeah. You talk about putting away or how important that is. I think we talked about before. I believe that acronym ALAP has probably caused a lot more harm than the time it's saved for people to say as well as reasonably practical, because you can use that noun in ways you couldn't use that for the full term.
Yeah.
Similarly, I've heard again tolerability being used to describe the risk of the dam on people rather than the risk of the dam that the owner is willing to bear.
Right.
Especially given the subjects of our risk assessments, the consequence is loss of life primarily.
Yeah.
And again, I see it when you put it within the framework of that tolerability framework, or the risk within that tolerability framework. The discussions, and at least the perception of those carrying out the risk assessments and decision makers, is it's tolerable to
us.
It's tolerable to the risk of the dam is tolerable.
Yeah.
To impact this number of people given this likelihood, rather than we as an organization consider this risk tolerable for us to not do anymore.
Yep.
And I do see that use of the word tolerable being more of the latter of the former of the latter.
And so the follow on of that conversation from a legal risk management perspective is what more could you have done?
Yeah.
So that is where it will be. and then it will be, is that reasonably practicable? And the reasonably practicable is the proportionate conversation.
Yeah.
You know, given, if you say, impacts on 1,000 lives, and we think the risk is so low, so we're going to tolerate that risk as a dam owner, the court's perspective might look a bit different with the benefit of hindsight, particularly saying, well, hang on, here's a few things you could have done that would have either prevented or mitigated that, and the cost is not grossly disproportionate to even your own accepted level of risk, so therefore you should have done it. The fact that it sat here in your risk matrix is not the answer to the question.
I think you really said earlier, having a technically good risk assessment and having a risk profile sitting somewhere doesn't mean you've done everything reasonably practical.
It does not.
As a follow-up then, why is it so important, or why do you think it's so important for technical guidance to be legally coherent, not just technically sound? I think that goes back to the point you mentioned about not proposing to be technical legal guidance.
I think we want it to be legally coherent because part of the risk is if it's not legally coherent and we have incidents and those guidelines are found not to be suitable in the context of legal risk management, the guidelines lose credibility, and I think that's problematic. We need credible technical guidance that we can point to as industry to say we relied on the technical guidance in part to help manage our legal risks. So I think the credibility of the guidance is important, and I also think, and this conversation has sort of borne it out, and what I referred to as the earlier conversations about this distinction between so far as and as low as reasonably practicable. At the moment, it strikes me as a very confused conversation, and I don't think that's helpful for anybody. So if we can get a more coherent conversation, if everyone's on the same page, understanding at least if we're all on the same page and saying this is what our legal obligations look like, you can, as an organisation, you can take legal risk. You can say we are making a decision to have that threshold and to put things below that. We understand that's technically not what reasonably practicable means, but we're going to wear that risk of efficiency, thoroughness trade-off, and you're making more informed decisions. I think at the moment people are making decisions thinking they're managing legal risk, when in truth I don't think they are.
Yeah, so really it's, again, about aligning, the previous question about aligning guidance with legal obligations. It's not throwing out more terms, but it's understanding the concepts and terms that are already there perhaps, and then building upon that as a starting point.
I think it would be really helpful to get rid of some terms. I think it would be helpful to get rid of ALARP. I think it would be helpful to get rid of tolerability. I think it would be helpful to get rid of acceptable levels of risk, except in Queensland mining legislation where they use that phrase. So again, and we haven't examined this, but you have to realise that I am talking today about legal risk in a reasonably narrow context of work health and safety legislation. There's insurance legislation, there's general principles of negligence and common law lawsuits, there's environmental legislation, which we haven't touched on, each of which set slightly different tests. They're all very similar, but slightly different tests. And I think understanding what those tests are without creating a language that purports to meet those tests when it doesn't would be helpful.
Who would be the appropriate entity to define a tolerability threshold or framework for an organisation or for a dam owner?
The organisation. It's the organisation's risk appetite that should be defining it. And even so, the health and safety legislation, which is the framework for protecting people, does not define a tolerability or any other threshold. It sets the test, which is reasonably practicable.
And a test that's completely separate really from any level of quantified level of risk.
Yes. I mean, the risk assessment process is an important part of the reasonably practicable equation, but it's not the end of the conversation.
for the first tolerability framework proposed by ANCOL was in 1994 with a statement that it was proposed in lieu of any frameworks or thresholds regarding safety to the general public imposed by dams. Is that correct?
No, I wouldn't have thought so. Occupational health and safety legislation has always created obligations on, in the old language, employers to ensure the health and safety of workers and others. There have been, in Victoria in particular, there was a spate of cases where members of the public were injured walking past building sites and things had fallen and collapsed, so failures of the building premises. So that's always been the case. There was a case in Esperance in Western Australia many years ago, well before 1994, where a toddler came into an auto parts store and pulled a rack of bull bars down on herself and was killed. Right. So the protection of the public arising out of the conduct of business and undertaking, that's always been a characteristic of health and safety legislation.
And before we wrap up, what key messages would you want dam professionals, including owners, regulators, consultants, designers, to take away about their duties under work health safety legislation?
I guess there's three. There's three, or probably four things. One is two things with the first one divided into three parts and one second part. The first part is to understand what the duty requirements under the legislation are. Mm-hmm. So the person conducting the business or undertaking the corporate entity, if you like, has to do everything reasonably practicable to ensure the safety of workers and others. Mm-hmm. Officers of that organisation, who are the most senior people in the organisation, they have to exercise due diligence to make sure the organisation is meeting its obligations. And everybody else, we're all workers and we need to take reasonable care for our own safety and the safety of others. And a significant part of that obligation to take reasonable care is to ensure that we comply with the policies, procedures and processes of the organisation. So I would like organisations to understand that. But fundamentally, I think the key thing organisations need to pay attention to, and I've said it a few times, but it's always where we end up, is whether or to what extent the organisation has got proper systems to manage the hazards in the business, and what assurance do we have that those systems are implemented and effective. And I think if we can direct a lot of our energy to understanding those two issues, I think that helps us shift the dial quite a bit in terms of looking after people.
Yeah. And last question, what advice would you give engineers who sometimes feel that law and engineering speak different languages?
They do speak different languages. I don't think that's something that can be ignored.
Yeah.
And I think what we really need is a much more multidisciplinary approach to these issues of workplace health and safety. And for better or worse, that's been compounded with the introduction of psychosocial regulations, which I think is clearly, historically I think many people have seen health and safety as a quasi-engineering discipline, which I think is wrong. And a lot of the great work that's been done, let me go back a step. I think technical change and engineering expertise has been the primary driver for reducing injury and fatality rates around the world. I don't doubt that for a moment. Some of the really interesting shifts in safety have been led by people like anthropologists and sociologists and psychologists, and I think that has an increasingly important part to play. And as I touched on a moment ago, the introduction of psychosocial risk regulations has fundamentally weaken's not the right word, but it has shown how far health and safety has moved away from an engineering discipline into other sciences. And I think we do need to spend a lot more time thinking about collaborative approaches across multiple disciplines to help it work better.
Yeah, and really from the sounds of, summarize the points you made, the engineering being one input into the overall decision about what's reasonably practicable to manage a risk.
Yes, and I've been fascinated for a long time about the number of engineers who purport to give legal advice about the management of health and safety risk, a lot of which is questionable at best.
Okay.
I don't spend a lot of my time talking to people about how to design and build safe bridges. That's not what I do. I find it extraordinary that engineers feel that they have the expertise to start providing legal advice about the management of risk. Engineers have an extraordinarily important role about the technical management of risk within their discipline, and that has got to continue, and it's very important. But if the development of health and safety over the last decade has taught us anything, it's the importance of a multidisciplinary approach with people understanding what their technical expertise is and very much staying in their lanes with a lot of collaboration.
So perhaps how a risk should be managed rather than if a risk should be managed is really the focus.
That would be an interesting dichotomy. I think that's right.
All right. Well, thanks for your time.
Pleasure.
Thank you.
Pleasure.